Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office with attorney Codi Dada, founder of the Codi M Dada Law Offices in Novato. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Shameika Rhymes, and Codi is back to help us cut through the legal jargon to help you protect your assets, avoid the headaches of probate, and leave a lasting legacy for your family. Codi, thank you for being here.
Hi, Shameika. Pleasure to be here. Thank you for having me.
Always good to see you.
Thank you. Likewise.
Well, in plain English, can you tell us exactly what is the probate process in California and when is it necessary?
Absolutely, I can. We deal with that all the time. So the probate is a process where someone has to file with the court, petition, they call it, and obtain legal authority to be able to manage the assets of someone else. Probate is necessary when the rest of the world, so to speak, the banks and the real estate agents and investment advisors, when they don't know who you would want to manage your assets, then those people don't want to get in trouble giving authority to someone, even though they may be your spouse or your children or a close family member, because they're not absolutely certain. So in that event, someone has to go through probate court and get legally authorized. And that requires filing a petition, putting a newspaper ad called publication, and giving notice to all the legal heirs and beneficiaries, and filing a proof of service with the court. If everything is completed properly, the court will issue what's called letters of testamentary or letters of administration, depending if there's a will or no will. Those letters, they call them, are a court order, and it appoints someone with the legal authority to access and manage someone else's assets. And with those letters, that person can now go to the banks and access bank accounts, investment accounts, deal with real estate, file taxes, and they can do anything they need to do to settle the estate of another person. That is what we want to avoid, because probate is a very expensive, tedious process that avoids many legal steps. A trust, on the other hand, avoids probate because it places your name on your assets as trustee of your trust. And the law is written in a way that says that when you put your assets in your name as trustee of your trust, it gives legal authority for everyone else in the real world, the investment advisors, the bankers, the real estate agents, and everyone else, DMV and your utility companies. It gives them legal authority to follow the instructions of your trust without having to go to court and get someone legally authorized. And one of the major instructions of a trust will be who is in charge if you are unable to manage your own finances. So obviously, we want to have all your assets in a trust so we can avoid probate. But oftentimes, things come up and we do need to go to the probate.
Well, people tend to hear that word probate and it, causes some chills. So is probate really as bad as people assume?
Well, probate is a multi-step process, and for someone who's never been involved with probate, it can be complex and it's very technical. And if you get things wrong, then you have to go back to the end of the line and wait several weeks, sometimes 4 to 5 weeks for your next chance to get it right. So the major phases are first getting appointed, which requires filing a petition, placing a newspaper ad, sending notice, and filing the proof of service. If that's been completed, then you're issued what's called letters of testamentary or letters of administration. At that point, everything has to be appraised, and an asset list has to be filed with what they call the probate referee. The probate referee determines the date of death value. Once the date of death value is determined, the final taxes can be settled, all the final obligations can be paid, and then once everything has been completed, we have to file what's called a final petition for distribution. And that is the narrative report that we have to file with the court that explains what we've done, how we've done it, and letting the judge know that everything is ready to be distributed. It's only when the judge approves everything and the court examiners have taken a look at the documents that you've provided and they are satisfied that everything has been completed accordingly. At that point, the judge will issue an order for distribution. In that order of distribution, it'll tell the executor exactly how to distribute the money and what amounts and to who will receive it. So, from a point of view of a ordinary person who has never been involved with probate, it can feel very overwhelming. But what we do is we help people by giving them a very clear cut path and a checklist of what they need to do, as well as doing all the legal formalities for them. They always have the control of all the assets, but a good attorney in this field will handle all those legal requirements of filing the papers and placing the publications and everything else that will be required for the judge to approve the final petition at the final phases of the probate process.
Well, there's this common myth that having a will keeps you out of court. Can you explain why a will is actually the ticket to probate rather than a way to avoid it?
That is a great question. That is one of the most common things that I see when I talk to people is that they feel that their will protect them from probate. But in reality, the will has no legal effect, unlike a trust. A trust is a document that is recognized in the real world without any court approval. But a will requires the approval of the court before it has any legal effect in the real world. Once the will has been lodged, then we have to begin the formal probate process, which requires filing a petition, putting a newspaper ad, sending notices to all the legal heirs and beneficiaries, and filing a proof of service. So that requires us to go through the whole probate process. And then once we get those court orders from the probate court, that's what allows the people named in the will to actually have legal authority to manage the assets and pay the bills. So that's why a will is something that we don't want to rely on. And that everyone with any type of significant assets, whether it's over 208,000 is the legal limit, should definitely have a trust in place to avoid that very expensive legal process called probate.
Well, what is and you may have just mentioned it, but what is the current dollar amount in or limit in California that triggers a full probate? And does a small bank account always require a judge's signature?
Well, yeah, it's not always requires probate. If your assets are less than 208,850, if you have more than that outside of a trust that's in your name personally, then probate is required. And what happens sometimes is people do have a trust and they have the majority of their assets in a trust, but they forget to put certain small bank accounts into the name of the trust. And the law allows us to use what's called a small estate affidavit. And we create this affidavit that has language that the outside world has to acknowledge. And basically, it allows the people who are entitled to the money to easily access those funds without having to go to court, as long as certain requirements are met. And the requirements are that all assets outside of a trust are less than the 208,850, and that there's no other probate proceeding that's pending, so we don't need to go to probate. And the person who's petitioning is actually the person who's entitled to those funds.
If we started a probate case in Marin County today, What is a realistic timeline for when the heirs would actually receive their inheritance?
Great question. So that's the disadvantage of a probate is it takes a long time. It could take anywhere from 9 to 18 months on a typical case, depending on the complexity of the circumstances. And the reason that it takes so long is because from the time that you file the petition to be acknowledged as the executor or the administrator of the estate is a 45-day waiting period. And then once you are approved as the executor, it usually takes a couple weeks to actually get the papers in your hand. Then the next step is filing the inventory and appraisal. So you have to identify the assets and create a formal list of the assets and send them to what's called the probate referee. The probate referee then has up to 30 days to provide a date of death value. At that point, that probate referee gets paid a percentage of the estate assets. Once you have the inventory completed and all the taxes have been filed and all the financial obligations have been settled, then we file what's called the final petition for distribution. That's a narrative report that allows the court to review everything the executor has done and approve the actions of the executor. That oftentimes, depending on the size of the county, can take 4 to 6 weeks. Okay, so if you add up all those different waiting periods, not to mention the time to sell the property and file the taxes, it's easily a 9 to 18 month period, presuming that there's no conflicts or any unusual circumstances that require additional services, boundary disputes, beneficiaries contesting a will, things like that. But that's a rough guideline. That's usually the case.
Okay, because I think people tend to wonder, like, how long is this going to take? But is it always necessary in California to have a home and other major assets appraised during the probate process?
It is, yes, one of the requirements of the probate process, which is another reason why we want to avoid probate. Unlike the trust, probate requires the assets to be formally appraised, and we have to create a formal, what's called inventory and appraisal on a judicial counsel form and file it with the county probate referee. The probate referee's job is to provide a date of death value of all the assets in the estate. Unfortunately, also, the probate referee gets paid a percentage of those assets for fulfilling that that purpose, right? So if your home, which in Marin County, home prices are very high, and your stock portfolio end up in probate, the fees can add up very quickly.
Now, who appoints the probate referee?
The probate referee is it's a political position. They're appointed
Oh,
by the
okay.
governor. Yeah, and they handle all the appraisals for that entire county. Some counties have more than one, but they are, yeah, that definitely a appointed position.
Okay. Thank you for explaining that. Well, how long do we have to wait for creditors like credit cards, hospitals, to file a claim before we can move forward with the case?
Right, and that's written into the probate code. So what it says is that the creditors have up to 4 months from the time that the letters have been issued. Remember, the letters are those court orders that are issued by the court once the petition has been approved.
Mhm.
That's also the reason why we put a newspaper ad called publication. It gives notice to the world that if they are owed money from this estate, that they have a limited period of time to claim those debts. So it's typically 4 months from the time the actual letters are issued or 60 days from the time the creditor receives notice. And that is part of the process is sending out the notice to all the beneficiaries and all the creditors.
Well, California has a set fee schedule for probate. How is that fee calculated, and why does it often surprise families about how high it actually is?
Absolutely. Yes. That is one of the major reasons why everyone needs to avoid probate is because the fees are based by the probate code. The attorneys don't make up the fees. The probate code has already written in that the fees are based on what's called statutory compensation. And the way that statutory compensation works is that the executor and the attorneys get paid 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and then 0.5% of the next 15 million. So you can see how that would add up really quickly. And now that fee is paid to the attorneys and to the executor. So, for example, on a typical $1 million estate, which is the average home here in Marin County, it's $23,000 that gets paid to the attorneys and $23,000 that gets paid to the executor. So you're looking at $46,000 in statutory fees. And that's based off the gross amount. So even if there's a mortgage, it doesn't include the actual equity. It's on the overall value of the estate before taxes, before expenses. And that does not include the filing fees, which are usually $435 to petition the court. And then the newspaper ad is usually about $300 to $350. Postage, probate referee appraisal fees, and other miscellaneous costs. So that, again, is a big reason why everyone should have their assets in a trust.
Thank you, Cody. This has been, that part right there was mind blowing to me because I had no idea all those fees were involved. But thank you for walking us through this process again.
My pleasure. Thank you, Shameika.
Well, thank you for joining us for the Trust and Estate Clarity with Dada Law Office with attorney Codi Dada. Please take a moment to subscribe, like, and share this episode with someone who needs to hear it. For more resources or to start your own plan today, visit dadalaw.com. Thanks for tuning in, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.
Dadalaw.com. Thank you for tuning in, and we'll see you next time.